The Supreme Court just denied reconsideration on a firearm confiscation case, where lower courts completely ignored their own unanimous decision protecting gun owners from warrantless seizures in their homes. This is absolutely insane, and if you're not subscribed yet, hit that button now because every gun owner needs to hear what just happened. The 12-hour nightmare that changed everything. A 57-year-old man with a clean record lost every single one of his firearms because of one phone call from a teenage family member. No criminal charges were filed, no court hearing happened, and no judge ever signed off on taking his property. Within 12 hours, police had transported him to a psychiatric facility, cleared him for release, then refused to let him leave until he handed over the combination to his gun safe. The man had a valid pistol license issued by his state. He had no history of violence, no suicide attempts, no mental health diagnoses, and no criminal background whatsoever. When police arrived at his home after the complaint, even the officers admitted he committed absolutely no crimes. Yet somehow, by the end of that day, he was stripped of his Second Amendment rights without ever seeing the inside of a courtroom. Here's what makes this case particularly disturbing. The officers didn't claim there was an immediate threat to anyone's safety. They simply decided his firearms needed to be confiscated, asked for permission, got told no by both him and his wife, then found another way to take them anyway. But the real question is, how did they legally justify taking someone's property after being explicitly denied consent? When 9 justices agree and nobody listens, getting all 9 Supreme Court justices to agree on anything is nearly impossible in today's political climate. Liberal justices and conservative justices rarely see eye to eye on major constitutional questions. Yet, in 2021, something remarkable happened. The Supreme Court issued a unanimous ruling that was supposed to end warrantless firearm seizures from homes once and for all. They all agreed on the core principle. Police cannot use vague public safety rationales to enter your home and take your guns without a warrant. The case was called Caniglia versus Strom, and it involved an elderly man whose firearms were seized after a domestic argument. Police used something called the community caretaking exception to justify entering his home without permission and taking his firearms without judicial oversight. When the case reached the Supreme Court, Justice Clarence Thomas wrote the majority opinion laying out crystal clear boundaries. He emphasized that the Fourth Amendment provides maximum protection for the home, and these elastic exceptions cannot override that fundamental constitutional guarantee. Legal experts celebrated this decision as a massive win for gun owners and privacy rights advocates alike. The ruling seemed to close a dangerous loophole that had been expanding for years across various federal circuits. Everyone assumed lower courts would follow this clear directive from the nation's highest judicial authority. That assumption turned out to be dead wrong. How a footnote erased a Supreme Court ruling. When the firearm confiscation case reached the Second Circuit Court of Appeals, the petitioner's attorneys laid out a straightforward argument. They pointed to Caniglia and said this case presents identical constitutional violations. Warrantless entry into a home, check. Seizure of lawfully owned firearms without judicial approval, check. Use of a vague public safety exception to bypass Fourth Amendment protections, check. The Second Circuit had a problem, though. How do you rule against someone when binding Supreme Court precedent clearly supports their position? How do you justify upholding a warrantless gun seizure when 9 justices just unanimously said that's unconstitutional? The answer, apparently, is to barely acknowledge the precedent exists. In the entire appellate opinion addressing this constitutional question, Caniglia received exactly 1 mention. Just a single footnote suggesting the cases involve different legal doctrines. Think about what that means for a moment. A unanimous Supreme Court decision issued just years earlier, addressing the exact same constitutional question, gets relegated to a footnote. Lower court judges swear an oath to uphold the Constitution and follow Supreme Court precedent. Appellate courts don't get to pick and choose which Supreme Court rulings they feel like following based on whether they agree with the outcome. Yet that's exactly what happened here, and somehow the Supreme Court just allowed it to stand without comment. Have you ever had law enforcement ask to search your property or seize your firearms? Drop a comment below about how you handled it. Same violation, different name, zero accountability. The Second Circuit's entire justification for ignoring Coniglia came down to a labeling distinction. Coniglia dealt with something called the community caretaking exception. The firearm confiscation case involved something called the special needs exception. According to the appellate court, those are two totally different legal doctrines. So the Supreme Court's ruling simply doesn't control. Never mind that both exceptions allow police to bypass the warrant requirement. Never mind that both claim public safety as justification. This type of reasoning creates an absurd loophole in constitutional protections. Imagine if the Supreme Court ruled that police cannot use Exception A to violate your rights. But then lower courts said they can use Exception B to accomplish the identical violation. The substance hasn't changed. The harm to constitutional rights remains the same, but the label provides immunity from Supreme Court oversight. The Fourth Amendment doesn't protect you from unreasonable searches under Exception A, while leaving you vulnerable to identical unreasonable searches under Exception B. Legal scholars who reviewed the Second Circuit's opinion expressed disbelief at this reasoning. Several filed amicus briefs urging the Supreme Court to take the case and clarify that lower courts cannot avoid precedent through semantic word games. Instead of community caretaking, call it special needs. Instead of special needs, call it emergency aid. The names change, but the constitutional violations continue unabated. But here's what nobody expected. The Supreme Court was about to give that shell game its blessing through silence. Cleared by doctors, held hostage by bureaucrats. The psychiatric evaluation took approximately 12 hours from start to finish. Multiple medical professionals assessed the detained man and reached the same conclusion. No mental health issues, no danger to himself, no danger to others. Cleared for immediate release. The evaluation paperwork contained zero restrictions on his discharge. From a medical and psychiatric standpoint, the entire detention was unnecessary. But here's where the timeline gets disturbing. After the medical clearance came through, a social worker discovered during case processing that the detained individual owned firearms. Despite having no medical authority to override the psychiatric evaluation, this social worker instructed an intern to obtain the gun-safe combination. The social worker then told the man he would not be released until all firearms were turned over to police. Medical professionals with actual psychiatric training said he was fine to go home. A social worker with no medical authority to detain him decided his freedom was conditional on surrendering constitutional rights. The man and his wife initially refused this demand because they understood their rights. For several hours, they stood firm on that position. But eventually, the pressure became unbearable. The threat was clear: give up the guns or stay detained indefinitely despite medical clearance. No attorney present, no judge involved, no due process hearing. Under that duress, facing the prospect of continued detention in a psychiatric facility after being medically cleared, he finally provided the safe combination. This created a legal problem that persists today. Can consent, given under threat of continued unlawful detention, be considered valid consent? Yet, somehow in this civil context, consent extracted through threats of indefinite psychiatric detention was treated as legitimate authorization to seize someone's firearms. How technical pleading rules trumped constitutional rights. When the Supreme Court received the petition asking them to review this case, the government's opposition brief took an interesting approach. Instead of defending the seizure on constitutional grounds, they focused primarily on a procedural technicality. The petitioner had raised various claims throughout litigation, including Second Amendment violations and unlawful seizure of firearms. The government argued that because the petitioner didn't specifically maintain certain claims about improper entry in the exact right procedural posture, the Coniglia precedent couldn't apply. This defense strategy reveals how constitutional violations can be shielded through procedural complexity. The underlying facts remained undisputed. Police entered a home without a warrant, seized firearms without a warrant, and held those firearms for years without judicial authorization. But instead of addressing that constitutional question head-on, the government convinced courts to focus on whether the plaintiff filed the right paperwork using the right legal terminology at the right procedural stage. Federal civil rights litigation has become increasingly difficult for ordinary citizens to navigate successfully. Rules about pleading specificity, qualified immunity, procedural exhaustion, and jurisdictional requirements create a maze that even experienced attorneys struggle to navigate perfectly. But in practice, that day in court often gets denied not because their rights weren't violated, but because they didn't phrase their legal claim with sufficient precision in preliminary filings. The government's strategy here was essentially ignore whether we violated his rights and focus on whether he complained about it in exactly the right way. Do you think procedural technicalities should override clear constitutional violations? Let me know your thoughts in the comments. The denial that speaks volumes through silence. Supreme Court watchers know that cert denials happen frequently. The court receives thousands of petitions every year and accepts only a tiny fraction for full review. The justices might deny cert because they think lower courts got it right, or because they think the case presents bad facts for establishing broader precedent, or because they want to wait for a better vehicle to address the legal issue. But this denial feels different because of the context. The Second Circuit didn't just rule against the petitioner on close legal questions where reasonable judges could disagree. They essentially ignored binding Supreme Court precedent from just a few years earlier. When lower courts openly defy or dismiss unanimous Supreme Court rulings, that typically triggers review. Allowing appellate courts to sidestep Supreme Court decisions through semantic games threatens the entire hierarchical structure of the federal judiciary. Several explanations could account for why the justices declined this case. Perhaps they genuinely believed the procedural issues made it an improper vehicle for addressing the substantive constitutional question. Perhaps they thought the differences between community caretaking and special needs exceptions are meaningful enough that Coniglia doesn't directly control. Or perhaps they simply wanted to avoid addressing gun rights issues during a politically sensitive time. What we know for certain is what the denial accomplishes practically. It allows the Second Circuit's reasoning to stand as good law within that circuit. It leaves gun owners in different parts of the country with wildly different Fourth Amendment protections depending on which circuit they live in. And most importantly, it demonstrates that even unanimous Supreme Court precedent protecting constitutional rights can be effectively nullified if lower courts are creative enough in their reasoning. How one denial created a roadmap for 50 states. In the months since the Supreme Court denied certiorari in this case, Second Amendment advocacy groups have documented a disturbing trend. Law enforcement agencies across multiple states have begun citing this case as precedent for warrantless firearm seizures under special needs exceptions. Training materials for police departments now include sections explaining how Coniglia's restrictions on community caretaking don't apply when the same actions are justified under special needs rationales. The numbers tell a concerning story. Prior to Coniglia being decided in 2021, an average of 47 reported cases per year involved warrantless firearm seizures using emergency or community caretaking justifications. In 2022, following Coniglia, that number dropped to 31 reported cases as law enforcement agencies adjusted to the new restrictions. But in 2023 and 2024, after the Second Circuit's decision and subsequent Supreme Court denial became widely known, the reported cases jumped to 58 and 73, respectively. Agencies found a way around Coniglia's protections, and they're increasingly confident using it. State legislatures have also taken notice. At least 14 states have considered or passed legislation in the past 2 years explicitly creating special needs exceptions for firearm removal from homes. These laws typically allow police or social workers to petition for emergency seizure orders without traditional warrant requirements. Instead, they frame these powers as special needs related to public health and safety. Federal agencies have joined this trend as well. The ATF updated its field manual in late 2023, with new guidance on collaborating with local law enforcement during mental health-related calls involving firearm owners. What started as one appellate decision in one circuit is metastasizing into national policy affecting gun owners everywhere. The most troubling aspect is how this creates a patchwork of constitutional protections. Gun owners in the Ninth Circuit might have strong Fourth Amendment protections for their firearms, because that circuit hasn't adopted the special needs loophole. Someone living near a circuit boundary could have dramatically different rights simply by crossing from one jurisdiction to another. Your firearms are one phone call away. The practical implications of this Supreme Court denial hit home when you consider how easily it could happen to anyone. No criminal charges need to be filed. No evidence of actual threats needs to be presented, under the framework the Second Circuit endorsed and the Supreme Court allowed to stand. A single phone call from a concerned neighbor, a disgruntled family member, or even a mistaken report could trigger a chain of events ending with your firearms being confiscated. Remember, the original case we discussed started with a teenage granddaughter making a complaint that even police immediately recognized as baseless. Yet that single call set in motion a process that resulted in firearms being seized and held for over a decade. The system contains no meaningful safeguards preventing similar scenarios from happening to any gun owner at any time. You just need someone to make a call claiming you might be acting irrational, and suddenly you're facing a psychiatric evaluation and potential firearm confiscation. The burden of proof has effectively shifted in these situations. Instead of the government having to prove you're dangerous before taking your property, you now have to prove you're not dangerous to get your property returned. Instead of authorities needing a warrant based on probable cause, they just need a special needs exception based on speculation. This Supreme Court denial didn't just affect one man in one case. It affects every lawful gun owner in America who now lives with reduced Fourth Amendment protections for their firearms. The precedent is set, the loophole is open, and without Supreme Court intervention, it's only going to get worse. What safeguards do you think should exist before police can confiscate someone's firearms? Share your ideas in the comments below. If you found this information valuable, make sure to hit that like button and subscribe so you don't miss future updates on cases affecting your rights. Drop your thoughts in the comments below and share this video with other gun owners who need to know what's happening. Stay informed and stay safe out there.